Hi, my name is Louisa Sijabat. I'm a liquidator and bankruptcy trustee. So today's question is, I've heard the terms lockdown DPN and non-lockdown DPN. What's the difference and why does it matter? So let's start with what a DPN is. A DPN is a director penalty notice. It's a legal notice by which the ATO can make directors of a company personally liable for certain debts of their company to the ATO in certain circumstances. Why does it matter? So, if there is a non-lockdown DPN, if this director receives the notice and it's a non-lockdown DPN, they can resolve the notice satisfactorily in one of a few ways. Firstly, by payment, which usually by that stage, in all practicality, there aren't enough available funds to pay. But you can also satisfactorily resolve the notice by either putting the company into liquidation, voluntary administration, or a small business restructuring if eligible for that, typically within 21 days of the notice, and that satisfactorily resolves the notice so that the director isn't personally liable for the debt. It can be dealt with satisfactorily by either payment or one of those appointment methods. Now, if it's a lockdown DPN, it can only satisfactorily be resolved by one method, and that is payment. And as mentioned before, there's usually insufficient funds at that stage for payment by any entity in the group, whether it's the entity that's the original taxpayer or the director personally, typically. Now, how do you get, or how does the ATO determine whether a director gets a lockdown DPN notice or a non-lockdown DPN notice? Noting that it is much preferable for most directors, or nearly all directors, to receive a non-lockdown DPN, because that means they can resolve the issue of the company's tax debt by placing the company into liquidation, voluntary administration, or small business restructuring, and in that way not become personally liable. Now, whether it's a lockdown or non-lockdown depends on when the company lodged certain documents with the ATO. Not paid, just lodged. So for anything related to GST and PAYG withholding information, the information must have been lodged with the ATO within 3 months of it becoming due for lodgement. Now, for any amounts reported to the ATO within that time frame, if a DPN were to be issued in the future, it will be a non-lockdown DPN, the type that can be resolved by also putting the company into liquidation, administration, or if eligible, small business restructuring. Also with that, any superannuation needs to be reported to the ATO within 28 days from the end of the quarter. And if that has been done, and later a DPN is issued down the track, then that also would be a non-lockdown DPN. Now, if those lodgement timeframes are not met, and for example, any GST or PAYG lodgements are done more than 3 months after the required date, and if superannuation is reported more than 28 days after the end of the quarter, if a DPN is issued in the future, those amounts become lockdown DPNs, and they can only be resolved by payment. This is a mechanism to encourage companies to keep up to date with their lodgements, even if they can't make the payments. Now, it is possible that if a DPN is issued, that there are both lockdown components and non-lockdown components on the same DPN, so please read the documents carefully.